on Bill 148, and we are now going to change gears a little bit and talk about drugs, alcohol, and marijuana in the workplace. So the background here, and one of the reasons why we chose to include this topic today, is because marijuana is likely to be legalized in Canada for personal use very soon. It was originally scheduled to become legal on January 1st of 2018. The reality now is that's probably going to get pushed back a little bit, but probably still in 2018 this will happen. Now, when the new laws come into force, it will enable employees to legally consume marijuana. Now, it doesn't mean that they're allowed to come to work stoned. It doesn't mean that they're allowed to have marijuana at work necessarily, but nevertheless, the legalization of marijuana will raise issues that employers will need to deal with. So when the new laws about marijuana come into force, the regulation of marijuana in Ontario will be pretty similar to the way that alcohol is regulated. So for example, just like we can now buy alcohol at the LCBO, so government-run establishments, soon you will be able in Ontario to buy marijuana from government-run establishments. In Ontario, there is a legal drinking age. For marijuana, there will presumably be an age at which you need to be before you can legally buy marijuana. And finally, another example, just like it is illegal to drive drunk, it will presumably be illegal to drive while stoned. So there are some very, very key similarities here. So in terms of policies, I'll just give some general advice here before we get into some of the cases. So your company's alcohol policy, if you have one, would probably say something along the lines of, employees are not, allowed to, consume alcohol during regular working hours, and they're not allowed maybe to have alcohol on them, and they can't be drunk, basically, right? So probably what a basic marijuana policy should say is that you can't smoke marijuana on company property during business hours. You can't be stoned at work, and we really don't want you to even have marijuana while you're at work. The exception there is going to be for medicinal marijuana, and you can address that in a policy by saying that if an employee needs medicinal marijuana, they have a positive duty to disclose that, at which point the employer will engage with that employee about, what accommodations, if any, are needed. And the case law has recognized that if an employee does not positively disclose that and then gets into trouble and starts testing positive for drug testing, the case law has actually upheld terminations for cause in those circumstances. One of the issues that is specific to marijuana is how do you measure the impairment, and there is some controversy about whether there really is an accurate drug test that will measure the current impairment of someone who has been smoking marijuana and will not just detect that they've had a joint, over the weekend. There's a case that was decided in 2017 involving the TTC, Toronto Transit Commission, involving random drug and alcohol testing. And in this particular case, the TTC had implemented what we call an oral fluid test. And if the result of that test showed that the employee had a reading of 10 nanograms per milliliter of marijuana, the TTC considered that to be impaired for the purpose of their test, and the court accepted that this manner of testing and interpretation of the testing was reasonably tailored to the health and safety purpose of the testing. So that's an example of how an employer might consider measuring impairment for marijuana. So I want to switch over to a different case right now about random testing. This one was also dealt with very recently in 2017. It's called Unifor and Suncor Energy Limited. There was a decision of the Alberta Court of Appeal, which is the highest court there, and probably this case will end up at the Supreme Court of Canada soon. And this case involves Suncor's attempts to implement a random drug and alcohol testing policy. So that's what was at issue. And at the Court of Appeal, the court said that, yes, Suncor's policy for random drug and alcohol testing for workers in safety-sensitive positions was legal and was acceptable. The union, Unifor, was not happy with that, presumably on the basis that this is an intrusion on employee privacy rights, and they have asked the Supreme Court of Canada to hear the appeal. The Supreme Court of Canada doesn't hear every case, so the Supreme Court of Canada first has to decide whether it will even hear the appeal. Probably it will, but that's not a certainty. Okay, so random drug and alcohol testing policies are permitted in Canada, but only in certain circumstances. And one of the sources of this comes from a 2013 Supreme Court of Canada case called Irving Pulp and Paper. So there's two criteria. First, the workplace where the testing is to be implemented needs to be highly safety sensitive or inherently dangerous. So examples, TTC, because we're dealing with bus car drivers, streetcar drivers, you don't want someone who is driving to be under the influence of drugs or alcohol. And the example from the other case, Suncor, oil company, working on an oil rig is dangerous too. You don't want people impaired while they're doing that. But secondly, the employer does need to show some evidence, not just that their workplace is dangerous, but there actually is a general substance abuse problem among employees. Okay? So the reason why there were some different decisions in the Suncor case related to what evidence Suncor actually presented. So Suncor presented evidence of positive drug and alcohol tests of their employees, which they did after accidents had occurred and also after what we call near misses or near accidents occurred. So that was the evidence that was presented at these hearings. The arbitrator originally said, well, that's not good enough. The Court of Appeal then said, well, hang on, I think we're holding Suncor as an employer to too high of a standard here. And that was the basis for which that decision was overturned. Okay? So as it stands now with the Suncor decision, their random drug and alcohol policy is acceptable because A, it's a dangerous workplace, and B, the court found that the evidence that employer presented about the substance abuse problem was good enough and was credible. Okay? So shifting back to the TTC case for a second here, this is another case involving a random drug and alcohol testing policy that was implemented. So the background here is that at some point in the future, there will be a full hearing on the validity of this drug and alcohol testing policy in front of a grievance arbitrator. But what's going on in the case is that the union is taking the position that this testing is a violation of the employee's privacy, and they are seeking a court order called an injunction to stop the random testing pending this full hearing at arbitration and pending the arbitrator's decision. Okay, and we'll go through some of what happened here, but after considering all the evidence, the court did not grant the union's requested injunction, and so has permitted the random testing to continue at this workplace. So the specific policy that was introduced was called the Fitness for Duty policy. It required drug and alcohol testing in a whole bunch of circumstances. I'm not going to read out all of them. So just to clarify, initially the policy didn't permit random testing, but then the TTC subsequently amended the policy in 2011. So that was really what was being contested here. And the decision is fairly long, but when the court made its decision to refuse to grant the injunction, the court found that this was because the balance of convenience favored the TTC, because number one, they were satisfied that the testing measures would detect impaired employees in safety-sensitive positions. So yes, having a bus driver who's about to drive a bus blow into a breathalyzer or do the oral test that we talked about before would result in a finding about whether or not that person was impaired. And two, because of that, now the public safety is increased because the risk of a driver driving a vehicle, drunk or stoned, has greatly decreased. Okay? The union, by the way, appealed this decision, but the court in this case that would have heard the appeal, called the Ontario Divisional Court, wouldn't even hear the appeal. So this decision is not going anywhere. But again, remember that it's pending a full hearing in front of an arbitrator. Let's look at some best practices here. So random testing can only be implemented for dangerous workplaces and for workers performing the dangerous work. Before implementing random testing, it is advisable to ensure there is ample evidence of a substance abuse problem specific to safety-sensitive workplace. So if there are incidents where there are accidents at work and it's revealed that someone was drunk, the employer should be documenting that. Implement a post-incident or near-incident testing regime at that workplace. So if there are accidents or near misses that are happening in a workplace, and the employer has, reasonable grounds to suspect that alcohol or drugs could have been a factor, that might be a basis for doing some testing. And the scope of the policy should be limited only to that part of the workplace. So if you have some employees who work in a safety-sensitive job area, but others who maybe just work at a desk and are answering phones, the office workers, that's not going to be considered a dangerous workplace. By any means. For policies, employers should have a clear policy on non-prescription drugs, including marijuana and alcohol use, that lays out the circumstances for testing. You can ask an employee for a proof of their prescription if they have medicinal marijuana. It should set out consequences for violations of the policy. Probably that consequence should not be an automatic termination. That's probably not going to withhold scrutiny in courts, and the policy should be reviewed regularly. As a quick aside, there was a study that was just completed earlier this month, actually, April 2018. It was done by a group called the Canadian Centre on Substance Abuse and Addiction. The title of the report is A Review of Substance Use Policies in Canada. And it's a long report. There's a lot in there, but interestingly, one of the conclusions of this report was that of the employers who had these policies, not too many of them were actually evaluating the policies in terms of whether their policies were actually helping to reduce drug or alcohol abuse in the workplace. So it's just a bit of a wake-up call to say, hey, these policies are important. So it's one step to have the right policy. It's also important to make sure that your policy is working, and if it's not working, to review it. Okay, we'll just get into one more area here. So don't forget that under Ontario human rights legislation, alcohol dependence and drug addiction is considered a disability. Okay, so that's one reason why you wouldn't want to have a policy that says that the employee is going to be automatically terminated if there's violations, because what if the reason they're violating the policy is because they're actually having issues with alcohol dependence, okay? And the Ontario Human Rights Commission, whose role is now to deal with systemic discrimination issues and to come up with policies on how to handle a lot of these issues, actually has a policy about when they say that drug and alcohol testing can be justified. So for example, there's a rational connection between the purpose of testing and job performance. The testing is necessary to achieve workplace safety. The policy was put into place only after alternative, less intrusive methods for detecting impairment have been explored. It's used only in limited circumstances. It does not automatically apply consequences following positive tests. The testing methods are highly accurate and are able to measure current impairment. The key phrase there is current impairment, okay? It's not so relevant to an employer whether an employee was, smoking marijuana on the weekend. What we're really interested in is whether they are impaired now. And then finally, that the testing would ensure confidentiality of medical information and the dignity of the participants. So quickly to conclude, there's a lot going on here. Okay, there's potentially some amendments that could happen before the laws actually go into force. So legal advice is recommended to help you adjust your policies or implement them. Again, review the employee manuals to make sure that you have sections in your employee manual which reflects some of these legal principles and new legislation. And proper training would be helpful, in particular for supervisors and also for employees, to help them recognize the signs of impairment. So that way, if an employer wants to implement one of these policies, there will be some evidence that you can present to the court if your policy gets challenged. Okay? So that concludes our presentations.